This is part 5 of torts. We're looking at breach. This is where defendant's conduct departed from standard of care. Plaintiff must establish elements by preponderance of the evidence, and that's anything greater than 50%. Breach may be established in the context or in the concept of res ipsa loquitur, where the accident is of the type that ordinarily does not occur in the absence of negligence. It's caused by an instrumentality in defendant's exclusive control, and the harm is not due to an act by the plaintiff. Now, this is circumstantial evidence. It does not apply if direct evidence is present. Exclusivity, as in it has to be in the exclusive control of the defendant, is interpreted broadly. Now, a majority of courts under res ipsa loquitur do not require a jury determination of negligence, and res ipsa establishes an inference sufficient to avoid dismissal, such as in a motion for summary judgment. Looking at causation, the defendant's act must be the actual and proximate cause of the plaintiff's harm. It's the actual cause if it's the factual or the cause in fact. It's the proximate cause if it's within the scope of liability. Looking at the actual cause, you look to the but-for test, such as but for the defendant's act, plaintiff's harm would not have occurred. Actual cause in the context of multiple and or indeterminate tortfeasors is where the plaintiff can't prove which defendant did it, such as in a negligent medical diagnosis. The but-for test will often not work. Here you apply a substantial factor test. Now, the substantial factor has been dropped by the third restatement, but the majority of jurisdictions still uses the substantial factors test. The test is, was the defendant's conduct a substantial factor in the plaintiff's harm? Actual cause in the context of two tortfeasors who contribute to an individual injury. Here both are the actual cause of the plaintiff's harm. Both are jointly and severally liable, which means the plaintiff may pursue a claim against any one defendant, and then that defendant may pursue a claim against the remaining defendant that wasn't part of the action. Looking at actual cause and alternative causation, this is where you have 2 to 4 defendants. The court here may switch the burden to the defendants to individually show the conduct of each was not the actual cause of harm. The reason for this is the burden may be too great on the plaintiff, though there is harm. Again, an actual cause and the concert of action, so where 2 or more defendants acting in pursuit of a common plan, design, and or goal, all are jointly and severally liable. And again, that means that the plaintiff may pursue a claim against any one defendant, and that defendant must then pursue a claim against other defendants for contribution. Looking at actual cause in the context of loss of chance, this is a negligent misdiagnosis that reduces the plaintiff's chance of survival. However, where plaintiff's chance was less than 50% before misdiagnosis, the plaintiff generally cannot prove actual cause. Here the plaintiff may recover reduced damages. This is the loss of chance doctrine. And the damages may be reduced by the percent difference in chance of recovery. So if prior to negligent misdiagnosis, the plaintiff had a 40% chance of survival, after negligent misdiagnosis, the plaintiff had a 25% chance of survival, the plaintiff can recover. The plaintiff's damages are reduced by that percent difference in chance of recovery. So 40% minus 25%, reduce damages by 15%. Yeah, proximate cause. Again, actual cause is the but-for test. Proximate cause is the plaintiff is within the scope of liability. Proximate cause, scope of liability, the key here is foreseeability. The defendant's liability is limited to those harms that foreseeably result from the risk that made the defendant's conduct tortious. Again, limited to those plaintiffs which might foreseeably be injured. You have the direct cause. The defendant may be the direct cause of plaintiff's harm. If the defendant is the direct cause, which is a cause without intervention of independent contributing acts, such as intervening or superseding cause, which we'll discuss below, then the result is foreseeable unless the result is freakish and bizarre. So if the defendant is the direct cause, which is a cause without intervention of independent contributing acts, then the result is foreseeable. So the defendant does something, nothing else happens, and the plaintiff is harmed, that harm is foreseeable. If the defendant does something, a bunch of other stuff happens, then the plaintiff is harmed. The defendant, that harm to the plaintiff may not be foreseeable depending on what all these other things that happened are. You have an intervening cause. Under proximate cause, you have intervening cause. An intervening cause is a factual cause of the plaintiff's harm. So here it is not a proximate cause. That intervening cause is one of those many things that happen in between the defendant's act and the plaintiff's harm. That is a factual cause, an intervening cause. It's a factual cause of the plaintiff's harm that contributes to plaintiff's harm after the defendant's tortious act has been completed. Now, a defendant may still be liable even though there is an intervening cause. Moving on to a superseding cause. This is where the defendant may not be liable. And a superseding cause is an intervening cause that breaks the chain of proximate causation between the defendant's tortious act and the plaintiff's harm. So the defendant commits an act, a whole bunch of things happen, and then the plaintiff is harmed. A superseding cause is one of these whole bunch of things happening that breaks the chain between the defendant's conduct and the plaintiff's harm. It severs defendant's liability. Looking at the intervening cause and the superseding cause, you have to look at the foreseeability. Again, proximate cause is all about foreseeability, and intervening and superseding causes are part of proximate cause. An unforeseeable intervening cause acts as a superseding cause and again breaks the chain. So a defendant acts, a whole bunch of things happen, then the plaintiff is harmed. If one of these whole bunches of things happening is unforeseeable as a result of the defendant's act, and the plaintiff is harmed as a result of that, one of the whole bunch of things happening, that breaks the chain of the defendant's liability. This may include extraordinary acts of nature, criminal acts, and or intentional torts by third parties. Now, negligent intervening causes are generally regarded as foreseeable. An example is that there's a defendant causes an automobile accident that breaks the plaintiff's leg. The doctor then negligently amputates the leg. That is foreseeable. You have criminal intervening causes. These are generally regarded as unforeseeable. This breaks the chain, such as the defendant causes a car accident, the plaintiff goes into the doctor rapes the patient. That's a criminal act, generally not foreseeable, and that would break the chain of the defendant's liability at that point. And that completes Part 5 of torts.